California cannot ban gun owners from having high-capacity gun magazines. A federal judge.
In March of last year, the Washington legislature passed a law banning the sale of ammo magazines that hold more than 10 rounds.
Tonight, President Biden announcing his first ever federal office of gun violence prevention.
California cannot ban gun owners from having detachable magazines that hold more than 10 rounds.
Having high-capacity magazines, the judge says there's no American tradition of limiting ammunition capacity.
Duncan Vonta mag ban. Alright, so let's dive into what's been cooking with the Duncan Vonta California mag ban case. This legal roller coaster has been nothing short of a drama-packed ride, and there's a lot to unpack. First things first, the legal proceedings are like a chess game played by legal eagles, and every move counts. After Judge Berettas gave California's mag ban a solid smackdown, deeming it a violation of the Second Amendment, things got wild. It was like a legal thunderstorm brewing over the sunny state. Now, the Ninth Circuit, usually known for its own set of rules, some might say quirky ones, did something nobody expected. They hit the fast-forward button on this case, deciding to take an immediate review. No warm-up, no stretching, just straight into the action. Unprecedented, right? And then came the stay. Judge Berettas' favorable decision was like a victory party getting shut down by the cops. The Ninth Circuit swooped in and put a hold on Berettas' decision, like hitting pause on a game just as you're about to score big. Frustrating, to say the least. But here's the twist. Multiple states decided to throw their hats into the ring. Amicus briefs started flying around like confetti at a celebration. Massachusetts, New Jersey, Arizona, and a whole bunch of others decided they were all in on supporting California's mag ban. It's like a legal team-up, Avenger style, but for mag bans.
California cannot ban gun owners from having high-capacity gun magazines. A federal judge.
Is it the most robust, far-reaching gun law in the history of the world? It is not.
They sometimes feel outgunned by assault weapons with large capacity magazines.
That they have taken away our right to have reasonable restrictions. We can have restrictions on speech.
Members of Congress are also trying to answer what the Attorney General just called the most difficult question in a democracy.
Now, let's talk implications. If you're in California and you've been holding on to those Freedom Week mags, things are still up in the air. Judge Berettas' ruling gave you a brief moment of freedom, but with the Ninth Circuit doing its shuffle, who knows what's next? The Supreme Court's Bruin decision is like the ghost haunting this whole saga. It's been sent back to the Ninth Circuit with a little note saying, hey, you might want to reconsider this. Will they play by Bruin's rules, or will they come up with a whole new playbook? It's like expecting a sequel but not knowing if it's a blockbuster or a flop. In a nutshell, the Duncan Vonta case is a legal soap opera. The stage is set, the actors are in place, and everyone's waiting for the next big twist. The implications for California's mag ban are like a cliffhanger. You can't help but wonder how this legal saga will unfold. Unprecedented immediate review decision. Hold on to your legal hats, because the Ninth Circuit en banc panel pulled off a move that left everyone scratching their heads. They hit the fast-forward button on the Duncan Vonta California mag ban case. It's like watching a movie on double speed, and you're trying to catch every plot twist without spilling your popcorn. So, what's the deal with this unprecedented immediate review decision? Well, typically, legal proceedings take their sweet time. It's a slow dance, like a legal waltz where each step is carefully measured. But not this time. The Ninth Circuit decided to skip the slow dance and go straight for the legal cha-cha. The case had barely caught its breath after Judge Berettas' ruling, and suddenly the en banc panel of the Ninth Circuit swoops in and says, we're taking a second look and we're doing it right now. No one saw it coming. It's like being in a game of poker and one player suddenly decides to reshuffle the cards just as things are getting interesting. Now, why did they choose this express route? Well, that's the million-dollar question. Some legal pundits are saying it's like the Ninth Circuit decided to break their own rules, throw caution to the wind, and make this case a priority. It's like they got a hot tip that this case was the legal blockbuster of the year, and they didn't want to miss out. There are whispers in the legal corridors that the Ninth Circuit wanted to grab the reins, take control of the narrative, and make sure this case was on their terms. It's like being in a heated debate, and one side decides to change the rules mid-discussion. Maybe they felt the urgency, or maybe they just wanted to be the legal trendsetters. Whatever the reason, the Ninth Circuit en banc panel made a move that's raised eyebrows and left legal enthusiasts buzzing with speculation. It's like watching a legal thriller where the plot twists keep coming and you can't predict what's next. So buckle up, because the Ninth Circuit's unprecedented immediate review decision has turned the Duncan Vonta case into a legal roller coaster. The reasons behind their lightning-fast move are still a bit murky, but one thing's for sure, this legal saga just got a whole lot more interesting. Stay against judge's decision. Alright, let me break down the latest plot twist in the Duncan Vonta saga. The moment when Judge Bonitz threw down the legal gauntlet only to have the Ninth Circuit slam on the brakes with a stay. It's like a legal showdown where every move is critical. First things first, Judge Bonitz delivered a ruling that had gun rights enthusiasts cheering and anti-ban folks shaking their heads. He declared California's mag ban a violation of the Second Amendment, a victory for those who believe in the right to bear arms. Imagine the legal equivalent of a referee blowing the whistle and declaring one team the winner. But, and there's always a but in legal battles, the Ninth Circuit swooped in like a referee with a different opinion. They issued a stay against Judge Bonitz's favorable decision. It's like freezing the game clock just as the winning team is about to celebrate, a buzzkill of epic legal proportions.
In March of last year, the Washington legislature passed a law banning the sale of ammo magazines that hold more than 10 rounds.
For a case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past.
But after Republicans let the law expire in 2004, and those weapons were allowed to be sold again.
Now to our other top story, new laws will impact how you purchase and carry firearms in the new year.
Of domestic abuse, you shouldn't have a gun. If you're on social media threatening the lives of people, you shouldn't have a gun.
For gun owners in California, it's a mixed bag of emotions. On one hand, you have this glimmer of hope with Judge Bonitz saying, hey, your rights matter. On the other hand, the Ninth Circuit is like the stern principal putting the brakes on the party. It's like trying to plan a victory parade and then having to put it on hold indefinitely. The stay adds an extra layer of uncertainty to an already complicated legal dance. Will Judge Bonitz's decision stand after the Ninth Circuit's review, or will it be tossed aside like last week's leftovers? Only time will tell, and in the world of legal battles, time moves at its own pace, slow and deliberate. So there you have it, the clash of legal titans. Judge Bonitz issuing a favorable decision, and the Ninth Circuit hitting back with a stay. It's like a courtroom drama where you can't predict the ending, and everyone's on the edge of their seats, waiting for the next big twist. Amicus briefs. Hold on to your legal hats, because it's not just California fighting the mag ban battle. A bunch of states have decided to join the party, and they're not on the side you might expect. Let's dive into this legal coalition. Picture this, a lineup of states, not just cheering from the sidelines, but actively jumping into the ring to support California's mag ban. We're talking about Massachusetts, New Jersey, Arizona, Colorado, Connecticut, Delaware, the District of Columbia, Hawaii, Illinois, Maine, Maryland, Michigan, Minnesota, New York, Oregon, Pennsylvania, Rhode Island, Vermont, Washington, and Wisconsin. That's a legal Avengers Assemble moment right there. Now, why are they teaming up to back California's mag ban? Well, they're not just here to watch the legal fireworks. They're bringing arguments to the table, and it's like a legal potluck where everyone brings their best dish. Their main pitch is all about constitutionality. In these amicus briefs, these states argue that while their own regulations might differ in substance, they share a firm belief that the Constitution allows them to tackle gun violence in a way that suits their local needs. It's like they're saying, hey, we've got our own way of doing things and it's all good. They're waving the banner of historical traditions, emphasizing that their approach aligns with what the nation has done in the past. It's like arguing that they're not breaking new ground, they're just following the same path that's been treaded on before. In their own legal language, these states are urging the court to conclude that California's limitation on the size of ammo mags is A-OK constitutionally. It's like a legal pep talk. You got this, California, and by the way, we're on your side. So while California's mag ban is facing challenges, it's also getting a whole squad of states saying, we're with you. It's a legal camaraderie that adds more layers to an already complex case. As the legal debate unfolds, these amicus briefs are like adding extra voices to the chorus, each singing the tune of why they believe California's mag ban is in harmony with the Constitution. Let the legal symphony continue. Plaintiff's argument. So what's the beef from the plaintiff's corner? They're not holding back. They're throwing punches at the en banc panel's authority to even be in the ring. It's like they brought a whole legal playbook to argue why this panel is overstepping. First off, the plaintiffs are waving the Bruen decision flag from the U.S. Supreme Court. They're saying, hey, the big guys upstairs already sent this case back down to the Ninth Circuit with a note that basically says, you got it wrong before, try again. It's like they're reminding the en banc panel that they're playing by Bruen's rules now, and they better stick to the script. But wait, there's more. The plaintiffs are throwing shade at the en banc panel's decision to review the case in the first place. It's like they're saying, who gave you the authority to be the comeback kids? You broke your own rules, and now you're trying to call the shots. It's a challenge to the panel's legitimacy, a legal mic drop moment. They're also suggesting an alternative path. Send this case back down to a traditional 3-judge panel or redraw the required randomly selected judges. It's like saying, let's hit the reset button and do this the right way.
California cannot ban gun owners from having detachable magazines that hold more than 10 rounds.
It is the bill Ferguson has been trying to get passed since 2016. That year, a 19-year-old used a high-capacity rifle.
Even law enforcement officials have told me and told other champions of this legislation.
But California Attorney General Rob Bonta argues they aren't necessary for private self-defense.
Their legal analysis is poor, their conclusions are misguided, their outcomes are dangerous.
In the plaintiff's eyes, this en banc panel is like that friend who volunteers to be the referee in a game but keeps changing the rules to favor their team. It's an argument not just against the authority, but also against the fairness of the game. The plaintiffs are basically standing their ground, telling the en banc panel, you've already messed up once, and now you're trying to do it again. We're not buying it. It's a legal chess move, challenging the opponent's right to even make a move. As the legal drama unfolds, the plaintiff's argument against the en banc panel's authority is a key plotline. Will the panel back down or stick to their guns? Only time will tell, but one thing's for sure, the plaintiffs are not letting this legal battle go down without a fight. Supreme Court's Bruen decision. What's the deal with Bruen? The Supreme Court basically dropped a legal shocker, reshaping the landscape for cases like Duncan Vonta. In a nutshell, the Bruen decision was like the wise elder saying, enough of the games, let's set things straight. In Bruen, the Supreme Court made it crystal clear. The Second Amendment protects the possession and use of weapons that are in common use. They basically threw out the old playbook, rejecting the two-step immediate scrutiny test that was causing confusion. It's like they said, let's simplify things and focus on what really matters. Now, how does this impact the California mag ban case? Well, it's like the Supreme Court sent Duncan Vonta back to school with a corrected answer sheet. The Ninth Circuit got a slap on the wrist for their earlier missteps and was told to take another look at the case, but this time followed the rules laid out in Bruen. Judge Bonitz had his moment in the sun, ruling in favor of the Second Amendment and striking down California's mag ban. But then came the twist. The case was sent back down to the Ninth Circuit by the Supreme Court, as if saying, we appreciate the effort, but let's get it right this time. So, every move in the California mag ban case is now under the shadow of Bruen. The Ninth Circuit, especially the en banc panel, is supposed to dance to the Supreme Court's tune. It's like the Supreme Court handed down a new set of guidelines, and everyone involved in the case has to play by these rules. The impact is enormous. It's not just about California's mag ban anymore. It's about setting a precedent, about clarifying what the Second Amendment really means in the context of firearm regulations. Bruen is the legal compass guiding this case, and whether the Ninth Circuit likes it or not, they've got to follow that compass needle. In a legal sense, Bruen is like the captain of the ship, steering it in a new direction. How this influences the final decision in the California mag ban case is still uncertain, but one thing's for sure. Bruen is the North Star guiding this legal journey, and everyone better be navigating by its light Freedom Week. All right, let's rewind the legal clock and dive into the saga of Freedom Week and Judge Benitz's initial ruling in the California mag ban case. It's a tale of temporary freedom, legal victories, and the winds of change. First up, Freedom Week. It's like a brief moment of liberty for gun owners in California. Imagine this. Judge Bonitz ruled that the state's ban on certain mags violated the Second Amendment. The decision came like a legal firework, and suddenly, Californians found themselves in the midst of Freedom Week. For a brief period, they could legally possess and acquire mags that were previously prohibited. It's like the legal heavens opened up, and gun enthusiasts were handed a temporary pass to enjoy their Second Amendment rights. Now, enter Judge Bonitz, the hero of the hour for those supporting the right to bear arms in California. His initial ruling struck a chord, declaring that the state's ban on mags holding more than 10 rounds was a violation of the Second Amendment.
Tonight, President Biden announcing his first ever federal office of gun violence prevention.
That we passed in 1994 with bipartisan support in Congress and the support of law enforcement.
Colorado's ban on gun magazines that hold more than 15 rounds is being interpreted one of three ways.
For removing weapons of war from the streets of America, we're actually telling them to repeal the Second Amendment.
People thought that the federal government would never be able to get a gun law bill passed again. They got one done in the last year.
But as with all good things, Freedom Week came to an end. The state, not thrilled about the sudden burst of freedom, decided to appeal Judge Bonitz's decision. The case was handed over to the Ninth Circuit, setting the stage for the legal drama that followed. Judge Bonitz's ruling, however, was a rallying point for those challenging California's firearm regulations. It set the tone for the legal battle ahead, and despite the twists and turns, it remains a significant chapter in the California mag ban case. It's like the opening scene in a movie where the hero takes a stand and you know the story is about to get intense. As the legal journey continues, Freedom Week and Judge Benitz's initial ruling remain emblematic moments, reminding everyone involved that the fight for Second Amendment rights is far from over. From District Court to Ninth Circuit. The legal journey of the California mag ban case has been a riveting saga, commencing with the landmark ruling by Judge Bonitz at the District Court. In a pivotal moment, he declared California's ban on mags exceeding 10 rounds a violation of the Second Amendment. This decision ignited Freedom Week, a temporary reprieve allowing gun owners in California to acquire and possess mags that were previously prohibited. However, the jubilation was short-lived, as California swiftly appealed Judge Benitz's decision to the Ninth Circuit. A 3-judge panel at the appellate level reviewed the case and sided with the District Court, affirming the judgment in favor of the Second Amendment. This initial victory for proponents of gun rights set the stage for a protracted legal battle. Undeterred, California sought an en banc review by the entire Ninth Circuit, a move that brought the case before an 11-judge panel. Yet, the plot thickened when this en banc panel, in an unprecedented move, decided to take immediate review, deviating from the traditional 3-judge panel route. This decision raised eyebrows, prompting questions about the panel's authority and the motivations underlying their unconventional actions. The legal drama intensified as the en banc panel issued a stay against Judge Benitz's favorable decision. This stay temporarily halted the enforcement of his ruling, introducing an additional layer of complexity and leaving gun owners in a state of uncertainty regarding the fate of their newfound freedoms. As legal arguments and briefings flooded the courtroom, both the plaintiffs and supporting states entered the fray. Their briefs presented intricate arguments either challenging or defending California's mag ban. The constitutional interpretations and implications of the Supreme Court's Bruin decision loomed large, casting a shadow over the proceedings. Now, the California mag ban case rests in the hands of the Ninth Circuit's en banc panel, with the legal world anxiously awaiting their decision. The outcome not only holds significance for California's mag ban, but also has the potential to set a precedent in Second Amendment cases within the circuit. The twists and turns in this legal odyssey have underscored the complexities and nuances of constitutional interpretation, adding a new chapter to the ongoing dialogue surrounding gun rights in the United States. Rule violation allegations. The legal turmoil surrounding the California mag ban case has taken an intriguing turn with allegations of rule violations against the Ninth Circuit's en banc panel. The very judges entrusted with upholding the law now find themselves under scrutiny for purportedly breaking their own rules in an unprecedented move. The heart of the matter revolves around the panel's decision to take immediate review of the case, deviating from the customary process of sending it to a traditional three-judge panel. This unorthodox maneuver has sparked allegations of rule violations, suggesting that the en banc panel acted outside the bounds of established procedures. Within the Ninth Circuit, responses to these allegations have been both diverse and contentious. Dissenting opinions, particularly from judges like Judge Van Dyke, have been vocal in calling out the en banc panel's actions. These dissenting voices highlight the perceived rule violations, emphasizing that the panel's departure from the traditional process was a breach of the circuit's own guidelines.
Today, U.S. Supreme Court justices refused to block a ban on assault weapon sales in Illinois.
We are paying for these weapons of war on our streets with the blood of our children.
These laws come into effect in the aftermath of mass shootings that have rocked the state and nation.
Ruling that law was unconstitutional, but the ruling will not take effect immediately.
Having high-capacity magazines, the judge says there's no American tradition of limiting ammunition capacity.
Amidst the allegations and dissent, the Ninth Circuit is now a battleground of legal arguments, with each side presenting its case on whether the en banc panel violated established rules. It's a clash of interpretations, with those critical of the panel's actions demanding accountability and adherence to established procedures. As the legal drama unfolds, these allegations against the Ninth Circuit's en banc panel add an intriguing layer to an already complex case. The responses and dissenting opinions within the circuit underscore the gravity of the situation, with judges within the same circuit openly challenging the legitimacy of their colleagues' actions. The outcome of this internal legal debate could significantly impact the trajectory of the California mag ban case. It raises questions not only about the specific rule violations alleged, but also about the broader implications for the integrity and adherence to procedural norms within the Ninth Circuit. The legal community watches closely as this internal dispute plays out, as it could have far-reaching consequences for the perception of justice and adherence to established rules within the circuit. Possible outcomes. As the eagerly awaited decision from the Ninth Circuit's en banc panel looms over the California mag ban case, legal analysts and enthusiasts engage in speculative discussions, considering potential outcomes based on the arguments presented, prior decisions, and the unique circumstances surrounding the case. The uncertainty surrounding the ultimate result gives rise to various speculative scenarios. In one conceivable scenario, the en banc panel could choose to affirm Judge Benitz's original decision, supporting his stance that California's mag ban infringes upon the Second Amendment. Such an outcome would maintain the initial victory for advocates of gun rights and could potentially establish a formidable precedent against stringent firearm regulations. Conversely, the panel may opt to reject Judge Benitz's decision, signaling a departure from the earlier pro-Second Amendment stance taken by the three-judge panel. This could imply a more restrictive interpretation of constitutional rights in the context of mag bans, setting a different tone for future Second Amendment challenges. Another potential outcome involves the en banc panel providing a nuanced decision that offers clarification on constitutional standards. This could address the implications of the Supreme Court's Bruin decision, providing valuable guidance for evaluating Second Amendment challenges related to mag bans and potentially influencing future cases. Alternatively, the en banc panel might choose to remand the case for further review, possibly by a traditional three-judge panel. This approach would acknowledge the complexity of the legal issues involved and allow for a more detailed examination of the case, aligning with the legal standards set by Bruin and other relevant precedents. Given the dissenting opinions within the Ninth Circuit regarding the en banc panel's actions, the decision might reflect internal disagreement. Some judges may express dissenting views, underscoring the divisions within the circuit on how to interpret and apply legal rules in the context of the California mag ban case. Lastly, it is conceivable that the en banc panel's decision might not bring a definitive resolution. The case could continue to face legal challenges and appeals, resulting in a prolonged legal battle that keeps the fate of California's mag ban uncertain and subject to ongoing scrutiny. That's all for this video, folks. See you next time.